All right. Good evening, folks. Welcome to Monday Night Law, October 25th, 2021. Oh, I have a special guest here, Tony Pellegrino, my brother from Pennsylvania right now, hanging out over there. How you doing, brother?
Busy, busy, busy. Almost as busy as you, Kirk.
Almost. I don't know. You've been getting out there and getting around a little bit.
Yeah.
Uh yeah, I'd like to kind of do some of those too, but we're really knuckling down with what we have going on with my three cases pending in the courts right now. So I just want to put out there to the people, we've been really busy at the office, even though some people took some time off to go hunting, and I was actually supposed to go down to California for our school board meeting and work on that kind of stuff. But the rest of the team went and accomplished some pretty good stuff, amazing stuff. So I want to throw props out there and love to my the team over there that just barely made it back home last night or yesterday, or Sunday night. So thank you all, team over there on the school team, putting this stuff together, and for your excessive labor and time. And I greatly appreciate you. And then, of course, the team at the office, which we've been, man, busting out paperwork and, of course, research. Reading means reading, putting stuff together for evidence, for other purposes. But we've got some stuff going on, let me tell you. And we'll talk more about that when you come into town, which you're headed this way here shortly.
Yep. I'll be in Friday night and we'll be hitting it all day long at the Nampa Civic Center all day Saturday.
Fourth annual We the People Idaho 2021. This is a fourth annual event. Tony's been the host. I've been kind of a silent co-host behind that all. This year we're doing a private law seminar from 10 a.m. To 11:30. Tony will speak, and then we'll break for lunch. And 11:30 to 12:30 is lunch, and then from 12:30 to 2, I'll be speaking and teaching, and we'll both have some syllabus there and some documents for you folks, some document templates and stuff like that. For those that want to do that, you need to email to pre-register. Email Tony at acla@yahoo.com, and we're charging $100 for this seminar. And then the actual We the People seminar will start at 2:00 with the first speaker. So I know it's going to be a little change up there, but that's what we've been putting out there for a little while, and hopefully some more people will get registered. Send that email to acla@yahoo.com. We need to have some numbers to buy you lunch because it's being catered. So we need to have those numbers over to the caterer so they know how many meals to prepare. So I know this is kind of last minute, but if you're wanting to attend this, education equipment seminar, law seminar here that Tony and I are going to do, we're going to educate you folks on what you can do here in the given situations that we have right now. What's most pressing? I mean, I'm looking at comments and stuff out there. Let's ask this question. What is the most pressing thing out here in society today, right now, that we can teach you folks? What's the subject matter? What do you think you need to be taught?
Can I take a wild guess?
No. Not even close to a wild guess, but shoot. Go ahead.
The most I take a survey. I've been speaking to like probably groups between 50 and 100 on weeknights, by the way. We're maxing out these places and people are coming in because their employers are saying you got to have the clot shot. within a certain amount of time, or you're losing your job. Or the other one is the parents are tired of masking up their kids, and the mama bears are arising again. These women activists are really inspiring. We need more men to step up, because these women are getting fearless to protect their children. But those are the two pressing things that I've been coming in contact. Just probably, I think I've done 10 seminars within the last 9 weeks, so I've been pretty busy.
Yeah, I think the pressing thing is of course the vaccine stuff, but just in general, the whole ideology that government has this power over the people when they're all supposed to be public servants. I mean, this is ethics in government. Fundamental principles of law of our form of government is that they are the servants and we are the masters. This has been flip-flopped, and there's a serious assumption that the servants are actually the masters and the people are the servants and the slaves. Other way around, people. And I think this is the crucial thing that we need to wake up to, is the fact that we, the people, have all of the power. We delegate certain powers, but we can't delegate a power we do not possess ourselves first. And the maxim of law behind that rule of law is what I cannot do in my person, I cannot do through the agency of another. And this is why in the ethics in government manual, as well as the ethics in government code, that the people, in creating the instruments of government that serve them, do not yield their sovereignty to the agency so created. Oh, that would be that sovereign citizen stuff. No, sovereign people. Citizens are the servants, civil servant, citizen, servant. Okay? They're the citizens. We are the people. People are free and equal, and we hold all the power. And we do not yield any of our power to government. None.
What's
and we're
the
not
open
subject
meeting?
to anything that you create.
How about the open meetings clause in the code about we don't yield our sovereign, in the Idaho code?
That's what I just cited. Title 74, subsection 201. The people of the state of Idaho, in creating the instruments of government that serve them, do not yield their sovereignty to the agency so created. That's exactly what it says. I have it memorized.
I used that in a brief in the federal court.
I'm using it in lawful notification letters. So this is the thing is we need to start learning what our powers are, what our rights are, because rights are the law. You know, declarations, declare, D meaning lay down, clarify. We're clarifying the law. That's how we lay down the law. We declare it. Rights are the law. And then we institute government, because we have to lay down the law first, because like it says in the Declaration of Independence, that to secure these rights, government is instituted. Yeah, that would mean the law, rights, came first, just like Hale versus Henkel says, that our rights are long antecedent to the formation of the state. Kick rocks, get off my property. Our rights are an aggregate, property, an aggregate of guaranteed rights. Those would be them unalienable rights, because they're our property. You can't place a lien on our property. It's common law trespass, a tort. So this is part of what I'll be teaching there this coming Saturday. Lawful notification letters, tort claims, and criminal complaints. Now, Tony will be going first, and just reiterate what you'll be doing.
Yeah, I'm going to do share a template that I've been using. It's a conditional offer of acceptance, and that's one way you get around the mandate. You say, fine, I'll take your cloth shop, but you have to indemnify me beforehand, because the vaccine companies won't indemnify me. So since you're requiring it, I'm going to do it. So I'm going to need probably a $5 or $10 million policy. You can't prejudice me. You change the contract and conditions of my employment. So I get reciprocity, I get equal consideration. So if you fire me, I'm not denying it. Then you're going to pay me a year's wages and pay to also retrain me in another occupation, plus damages. So special damages. So yeah, that's a good way to go about it, instead of trying to all these exemptions. What filling out an exemption is asking a permission. And I've had an exemptions that work, but how do you feel about these exemptions, Kirk? I'm just totally bypassing them at this point.
Yeah, I'm not really, I mean, I'm not really doing exemptions. I'm doing lawful notification letters. You're to cease and
Yeah.
desist right now because none of that's lawful. Government does not have the authority to order us around. And this word mandate that keeps flowing around out there, again, mandate actually comes from the writ of mandamus. And it is from a higher court to a lower court, or in reading the books that I've got there. Thank you, Michael Kolovinsky there. Those American jurisprudence, pleadings and practice forms, those writs of mandamus, they're to instruct a lower court, or in some instances, public servants to do their job. At no time can, and again, this is from the judicial branch. So can somebody please explain to me these mandates that they're claiming that are mask mandates and mandate this and mandate that? The last time I checked, a mandate was 2 guys going fishing or the Obamas going to see the movies.
That's a mandate. Yeah. The other thing is how to wield your subpoena power. I'm going to be sharing some stuff on that too. I've gotten really to be able to do some really good paper colonoscopies. And when you drag them in by the short hair and get to subpoena them and depose them under oath, because these people don't like answering questions. And when they get a federal subpoena, they're under criminal violations if they do not show. So under criminal sanctions. And so I've had a really good time with subpoena power. It's almost not fair.
Yeah, once even where I'm at in these criminal cases, I can subpoena them, I can depose them. So, the power is there at any time, which, for a little bit of an update out there for everybody else, they tried to order us to mediation. And after they sent over the agreement, the contract, it's like, wait. Oh, and then you're citing this rule and and I'm like, well, wait a minute. This is all voluntary. And then the grounds. There's 4 distinct grounds for going to mediation. Not one of those grounds would apply here, because I'm not interested in pleading guilty to a lesser charge. I'm not willing to talk about how much I'm going to pay you guys in damages and that. No, that's not on the table. It's not an option. In fact, I've already filed my notice of special appearance objecting to the personal jurisdiction. I filed an affidavit. Okay. I'm accusing you all of being actively engaged in human trafficking through the birth certificate and all that good stuff. Nobody's rebutted that affidavit. Now, what we did is we decided, is like, wait a minute, why would we even go to mediation? It's just a waste of time. It's a waste of everybody's time. Because there isn't anything. And then not only that, it says it's supposed to be a neutral mediator. Oh, well, the judge over here is going to be a mediator. No, a mediator would have to be a disinterested third party. Outside of government, outside of the court, and most definitely outside of being a magistrate or judge, as you guys like to call yourselves, but you're magistrates, which magistrates are supposed to be our trustees and servants, and at all times are supposed to be amenable to the people, not to the corporations. So we got a little bit of a problem. So I sent an objection to the order to mediation, which there again, it says the parties can make a request. Well, neither of the judges are a party to the case, right? Last time I checked, judges aren't party to this case. They're going to become a party to a different case, but the case that's before the court, They're not a party to that. They're not supposed to be. So I don't see how any magistrate can be a neutral party or a neutral mediator. So I kindly sent an objection to the order to mediation and, cited everything that's in there. It's voluntary. And at any time, we can say, no, we don't want to participate. Well, I don't even want to sign the contract. So I just said, your request for mediation is hereby denied because I don't consent. And then I served the lawful note or request for discovery. So some of my people out there have had some glimpses of this request for discovery. And I just want to let you know, we tidied that up and we filed that. They got 14 days to respond. Now, the other thing is I've already went to our local Central District Health and made a public records request for proof of, the thing. And of course, there's no reports of that. They don't have that information. Uh-oh. How in the heck has Central District Health been running around doing these orders of quarantine and you have no proof?
Can I interject?
Sure.
I just want to reiterate stuff that you've known for a long time. I think this was about maybe 8 or 9 months before COVID. The Attorney General put that memorandum out on improper guidance documents. So I took page 2 out, kind of threw it in my syllabus. And it reads, this is real specific. Bullet point number 1, guidance documents should identify themselves as guidance and disclaim any force or effect of law and avoid suggesting that the public has obligations that go beyond that which is set forth in applicable laws. Guidance documents should clearly state that they are not final agency actions and have no legally binding effect. Guidance documents should not be used for the purpose of coercing persons. Guidance documents should not use mandatory language as shall and must.
Wait. What was the word you used? Mandatory?
Yeah, well, like shall, like in the Second Amendment where your rights to bear arms.
They're using the word mandate.
I know, right? Here's one more. Let me just throw one more. To the extent of guidance documents, these set out voluntary enforcement or voluntary standards and will not in itself result in any enforcement actions. There it is. Barr clarified what exactly guidance is and what it is not. And this is a total fraud.
Yeah. And it is fraud under duress, coercion, and threat. They're used threats of force and violence. This is what the showdown that's being that I'm forcing in the courts. What lawful authority do any of you guys have? Where's the laws of creation of all these different states of Idaho that is in my paperwork? It's not like I'm just making this stuff up. So if they try to come back and say, oh, well, he's just, we don't need to supply that. He's just making unlawful requests or whatever verbiage they'll end up coming up with. I'm going to pull it right from my paperwork and send it in as an exhibit. Here it is on this document that you sent me that's in the court of record, says the state of Idaho in all capital letters. This one says state of Idaho in all capital letters. This one over here says lowercase s state of Idaho. This one over here says upper and lowercase state of Idaho. So will the real state of Idaho please stand up? And I'm going to need your corporate charter. I need to see the laws of your creation. Are you even lawfully created? Because again, remember folks, all political power is inherent in the people. We have the right to alter, reform, or abolish anything at any time we deem it necessary. Thing, capital T, thing. What's a thing? Remember? Person, place, or thing? That's a proper noun. Oh, whatever the state of Idaho is, whichever one is the thing, there can only be one thing. So the other three are going to have to be abolished, and stop using that, because I actually know what the hell's going on behind all that. But
Is that the one thing that they were trying to get to in City Slickers? Remember Curly? You need to know the one thing.
the one thing. So, I mean, I'm attacking everything. The bar. I want the laws of creation of the Idaho State Bar. I want the laws of creation of City of Boise and Boise City, because you're using both. So which one is the real one? I mean, I have your Duns and Bradstreet number for the state of Idaho and for the city of Boise. So why are you listed on Dun and Bradstreet as a corporation when this is supposed to be government?
And shouldn't all corporations pay taxes? I bet you that state corporate state charter isn't paying no taxes either.
What IRS
Just
form
saying.
is that again? To report them for failure to pay taxes?
Yeah. Laws for thee and not for me.
And yes, again, reiterating, I'm going after the bar because I asked for that, right? I want the laws of creation. I want the laws of creation of the Idaho Code. I want the laws of creation of the Code Commission. Yeah, I got all sorts of things. The Department of Health and Welfare. I want the laws of everything that is applicable to, that's right in the paperwork in my cases. So I'm not asking for something that's not already in the paperwork. I mean, they have Idaho State Bar number. What the hell is the Idaho State Bar number? What the hell is that? Because remember, the fundamental principle here is that of our republic is that no man or set of men are entitled to separate emoluments. Those emoluments would be foreign to our form of government and repugnant to our law. Read Article 1, Section 9, Clause 8. No titles of nobility or emoluments. Any advantage, profit, or gain received due to one positions of employment or holding of office. Aren't you guys supposedly officers of the court? So that you'd be under the judicial branch. And, well, wait a minute. Article 6, Clause 3 requires you to be bound by oath or affirmation to support this Constitution. Why is there a Foreign Registration Act? You're all foreign agents.
They're not properly lined up underneath the executive branch, actually, with their license.
Well, no, they're in the judicial branch.
That's the whole problem.
Well, yeah, actually, they're both, right? Because the general prosecuting attorney, also known as the attorney general, is the head of the executive, right? Well, I mean, aside from the governor, I mean, the head of prosecuting attorneys. Fundamentally and principally, that's our form of government, that's the general prosecuting attorney, and more specifically, general. That's a rank in the military. That's Admiralty jurisdiction. So yes, prosecuting attorneys under the general prosecuting attorney would have to be licensed, right? But what is a license? Seeking permission. Well, who in the hell do you have to seek permission from? The attorney general and the people, because you have to be elected. That's whose permission you need, not any set of men, because that would be, again, foreign to our form of government and repugnant to our law, the law of the land.
Well, even the legislature, in their own manual, says that the Constitution is organic in nature and stands on a higher plane. So you can't take something on a lower plane and put it above what the Constitution says. And they're doing it all the time. And it's because we're not stepping up and calling them out. So people need to come to the conference. You know, Kirk, when I go to these conferences, I end up meeting, other gurus and whatnot. And there's like a synergy, there's like an impartation when you go to a law conference seminar in person. I've probably been to I've attended about 4, I've hosted a bunch. But every time I went out, whether I paid $500, whether I flew to Vegas, LA, San Diego, Sacramento, I've been to some amazing conferences, and you meet other people and you end up getting good stuff from those who are attending the conference too. So it's totally well worth it. It's investing in your future. And there's wisdom in a multitude of counsel, and we need to get around other people and just get out of our comfort zone and jump on an airplane and head out to Boise, and spend a day with some like-minded people. It's really empowering, encouraging.
Yeah, there is something about the in-person experience, right? And I hate using that in-person experience, but being there physically, there is a difference between here online and physical presence.
Yeah, don't watch a movie, be part of it.
Right? Take some action. People, we need to stand up. We need to stand up. Well, do you know what standing means?
Right.
Standing means you have a right to a cause of action. What's the action you're going to take? Not physically just standing there. That doesn't do anything. We're actually going to have to take some action. And in our settled, civilized society, we're settled on the law. We're civilized because we have a civilized process that is due, which comes from the law of the land. And the law that the law of the land refers to is the common law. Welcome to the American common law, folks. That's the law of the land. That's that law that the law of the land refers to. The same as due process of law, which, by the way, is synonymous to the law of land. They're interchangeable. They mean the same thing. So the law that it refers to is the American common law. Oh, I'll be darned. Due process of law comes from the common law. Yep, it sure does. And thanks to Rob Logue out there, we found some books. We ended up buying like 89 books, but at $1 a piece. A lot of them were the sessions, Idaho session law books. Yeah, all the evidence of their fraud. We got quite a few of those. So, but in the Idaho code, it'll cite da 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 da. Well, you pull open that book and there it is right there. And again, this goes back to something that a lot of people aren't even aware of: substantive due process. Now, this comes before due process of law. Whoops. So it's actually the laws of creation. Do they actually have the authority to create that? Well, what's the first fundamental principle of group decision in Mason's Manual Legislative Procedure, 2010 edition anyways? The group must have jurisdiction. Well, where do they get jurisdiction from? It sure in the heck isn't from the Idaho Code. Jurisdiction is that delegation of power, the emoluments of the office, or in this instance, there's two types of jurisdiction that we're talking about here: personal jurisdiction and subject matter jurisdiction. Personal jurisdiction, well, a government only has personal jurisdiction over that which they create. Corporations, right? I mean, that goes right back to Hale versus Henkel. There's a reserved power in the legislature to investigate the corporation and look at to see if it's violated its own laws of its creation. So that's what I put in my request for discovery: the laws of creation of all these corporate entities and associations and different, because that's all it is. They've hijacked our form of government. They fundamentally altered our form of government. And it's up to us to claim and exercise this power to alter, reform, or abolish anything and any time we deem it necessary. Now, one of the lost arts here is jury nullification.
10th Amendment.
No. Virginia Declaration of Rights.
Yeah.
June 12th, 1776, the right to a trial by jury. Those benefits of the Declaration of Independence, that it talks about, declared act of tyranny for depriving us of the benefits of trial by jury. What's one of the benefits of trial by jury? Would that be to abolish unconstitutionally passed, unlawfully passed enactments of the legislature? Or how about any policy made by a guidance document? Or, yeah, see, this is how we're supposed to be controlling our republic. With the jury. Not everything has to go and get permission from the Supreme Court. No, jury nullification. We have this power to nullify what they create. If I can present the evidence that says, here it is in the Constitution, they don't have subject matter jurisdiction. I can't find it. Where is it? Oh, that doesn't exist. So we have to abolish that. That's grounds to abolish. And we don't seek permission, especially from the ones who created it, to abolish what they created. Now, there is a process, right? They say we're supposed to go with a petition to the legislature. And then we're supposed to, within that petition, you go over to the judicial branch for a constitutionality challenge to the statute. But the problem is they're not even creating statutes. I open up these books and I have one pulled up right here that I'm looking at right now, doing some research on the school board, the trustee and all that. Oh, being enacted by the legislature of the state of Idaho to amend the Idaho Code.
Only 3 branches of government.
How can the legislature make amendments to the Idaho Code when the Idaho Code is not the law? They would have to make amendments to the statute first, and then the code committee. I mean, if we're going to go with this being legitimate, because like Peterson versus Peterson, the Idaho Code is not the law because the Code Commission has no legislative authority. Well, who's the Code Commission? 3 members of the bar. Wait a minute. What are these 3 members of the bar? Again, the fundamental principle. No man or set of men are entitled to separate emoluments. The legislature cannot delegate its power. That's Article 1 or Article 2. No. Yeah. Is it Article 2 of the Idaho Constitution?
I'm going to have to look in PA's Constitution because these guys unanimously voted to extend the emergency till March of next year. And according to their language, is giving the Department of Education and Health authority to make this stuff up as they're going along. It's just
that's what I was just reading earlier today. It's exactly the same stuff. Got it pulled up right here.
I guess communism's a pretty game plan. It doesn't change. It has the same end game, the same pathway there.
Yeah. And it's all being orchestrated by the bar.
Yeah, and these solicitors, these aren't the smartest people. I don't think some of these solicitors know the difference between a code and a law. Because what they're doing is they're counseling these boards to just continue to force these infringements upon the people. And you need to sue your solicitor too, by the way. You need to go after them also.
Yeah, go after them as the man, right? Because everything else is just in their proper person, but those emoluments don't exist. And it takes a man to take the action. And again, this is the common law, torts. So this is part of what I've been trying to teach people here, at least a little bit. And what we've actually been doing at the office, we've been filing tort claims left and right. So this is the precursor, according to the Idaho Code even, the precursor to the Title 42, 1983. You file the tort claims and they have 90 days to respond. And then if they don't come forth and say, yeah, you can you go to civil. And remember, this is about rights violations. So you have to put in there what rights were violated, what was the conduct that was violated the right, and what are the damages. Now it says in there you can't go for punitive damages, because you got to go through the criminal process to get punitive damages. That's O.J. Simpson trial. That's the reason why they had to do the criminal process first before they could go do the civil process, because they were wanting punitive damages, but then he wasn't convicted, so they couldn't go for punitive damages in Title 42, 1983. But that's the whole reason why they had to do the criminal first. But this is, this is the informal part, because this is the common law. It doesn't have to be perfect to do tort claims. You could scribble some stuff down on some toilet paper and give it to them, to be honest. We're not, technically speaking, according to the common law, this doesn't have to be, and even according to their own code, it doesn't have to be in a proper format. Now, when you go to do Title 42, 1983, Tony, that stuff's kind of got to be in proper format, does it not?
Yeah, I've had to a lot of practice. I've got about 200 entries on the docket in the last 3 years. So
yeah.
Yeah.
Have you guys had any of them thrown out because it just wasn't in proper form?
No, when you're a non-attorney, the court grants you an opportunity to fix your mistakes. So that's always cool.
Oh, didn't you tell me that the judge actually asked you guys to fix one of your documents or something like that? Or
What it was, I think Carla, before she let me educationally inspect her document, she panicked because she thought they were gonna come and foreclose on her on the eminent domain. So she panicked and she threw in the temporary restraining order in before I had a chance to look at it. And so, yeah, we were allowed to correct that, because you have to have all the elements in order for the judge to grant you that according to the rules. And yeah, the federal rules of procedure and evidence are important, especially when you do judicial notice. And it seems like our defendants in the case, pretty much almost all 13 of them, was making it very easy to get discovery, because these clowns are being sued by multiple different plaintiffs in different situations. And so when you have something like that, and you file a judicial notice on the record, the court is able to validate and verify that which you're having non-adjudicative facts, which are that which can be verified, that are unquestionable and undisputed. Like, you can go on to the either PACER or the Court of Common Pleas and look up that Union Township has been sued like 20 times in the last 3 years. So it's like, their attorneys are calling this frivolous, but there's 19 other people that sued them in the last 3 years, and 4 of them are current. So yeah, good luck with that one. Sorry, you've been given fair notice, and there's plenty of judicial notice to warrant probable cause of a cause of action. So
yeah, the thing is that the Supreme Courts have all said many times, although Idaho kind of switched on that here recently, but the fact is pro se litigants are not supposed to be held to the same high standards as these bar school folks.
I've never seen a motion to extend time be denied ever, out of I don't know how many, lots.
Yeah.
So,
at least on the first one, for the first attempt, maybe even second.
I've never been denied for more time. So if there's a situation, and this is the deal that you bring up too, because they want you to explain, one of the elements is what in good faith, what are you doing in good faith that we should give you more time? And part of it is, one of the reasons is, you know what, this law firm gets paid to do this full time. I have a regular job. I'm the only one in this proceedings that are not getting paid, and I have a full-time job. So I have to find my extra time, my vacation time, my leisure time to sit here and try to conform to all these elements and, all these procedures and be in compliance to all the rules. And so they always give it to us. I mean, every time.
Right. I mean, that's a valid argument. I mean, it's truthful, right?
Yeah.
So for the most part, in any given situation, yeah, you more than likely, if hey, can I have some more time, please? Yeah, sure. You assert the grounds for continuance, they'll grant it. It's about logic and reason for the most part. But don't go in successive, like third motion for continuance for the same thing. That's starting to push it. Once yes, twice yes, third time, you better have some other reasons behind not being, ready to proceed to the next step or whatever it is.
I think we've had 6 extensions of time on this one case. We've got them every
Well, yeah,
time.
but each one was at a different
Separate.
stage, a different step.
Yeah.
Like if you're going to file this certain motion, well, I need a continuance to file the motion. I'm not prepared yet. Oh, well, I need a continuance to, okay, how much more time you need to file this one motion or this brief or to do this deposition or to, whatever it is. But yeah, you can get many different continuances throughout a case. I just wanted to clarify that it was specific to the same thing over and over. It's not going to, about the third time, you're going to get burnt. Because you're stalling basically, but yeah,
It's on the substantive due process and procedural due process. The first person to sue the governor and suing the governor and trying to sue the president and all that stuff, we need to start taking pawns off the board. But this one law firm, they sued the governor and the health department director, and they got expedited discovery and injunctive relief, and they settled that case within 3.5 months. And the Judge Stickman in the Western District of Pennsylvania and the federal court ruled that there's no such thing as a new normal. It's either constitutional or it's not. So he ruled against them not allowing substantive and procedural due process. It was an illegal seizure, Fourth Amendment illegal seizure of businesses. And they in the process of doing that, they violated the just compensation clause of the Fifth Amendment, that if the government's going to take something from you and demand that, then they need to give you just compensation. And that doesn't include those little grants that you apply for. Just compensation, there's no application for just compensation. And if you don't like your just compensation, you go to a board of viewers. That's kind of like, arbitration. But when Carla went through mediation, Kirk, I was just like, she ended up paying both parties, like you said you were going to pay, but she didn't mention that, and she ended up spending like $2,500 in mediation, and it was a retired family court judge that was part of it, and he was charging $500 an hour for mediation.
yeah, waste of time, waste of money.
Yeah,
which there ain't any money, but it's extortion, it's embezzlement.
Yeah, I mean, the very first thing was, are you going to give me $1 million and resign from your positions? And then we may not criminally charge you. That was her bottom line. And,
well,
which,
that's about what I was going to offer. Give me $10 million for both of these cases for violating our rights, and we'll hold these particular people harmless, but the rest of you, your ass is mine. But after reading the rule of procedure that they cited, a rule 18.1 there, what the 4 different grounds are for going to mediation, I'm like, none of those apply. Why would I even go to mediation, even if we were to say a disinterested third party outside of the court, outside of the government? Okay. Even then, if we're restricted to these 4 different grounds, it's all geared towards them.
Well, you
It's
know what their
never geared
motto is?
towards the defendant as a win. It's
You
like,
know why that you go to mediation? Because there's plenty of money to go around. There's enough money for all the bar members, right? And the mediator, they said that in family court one time. There's plenty of money to go around to everything. We got the guardian ad litems, we got the counselors, we have the behavioral psychotherapist. You take that one I
Psycho
forget
the
what it was
rapist.
called, the Minnesota multifaceted psychiatric evaluation. That's a $5,000 fee for that test in family court in California. Is that outrageous? Per person.
Yeah.
It's
I thought
totally.
justice is to be without sale, denial, or delay. That's as old as the Magna Carta of 1215. To no man will we sell, to no man will we deny nor defer rights or justice. That's chapter 40 of the Magna Carta of 1215.
Yeah, a lot of people need to go back to school, huh?
Yeah.
Yeah, what's interesting is these bar attorneys, they rely on opinions instead of law. Case law is not law. It never was. It never will be. And these judges want you to use it.
Oh,
And
yeah.
Fred Kelly Grant, he really had to work me over to talk me into using do it. Give the judge a reason to rule on your behalf. But I'm going to share a little bit about his 10th Amendment nullification action through coordination through NEPA, the National Environmental Policy Act, because all the tree huggers think that, well, that just applies to the natural environment. There's 4 different elements to the environment under that act. That's the human environment, the natural environment, the economical environment, and the social environment. And when any of these environments are upset, then there's a lack of consistency. Then you nullify any type of federal mandate. You can use a local legislative body like we did in Heartland, Wisconsin, and we smacked down the Food and Drug Administration for under $15,000. And you wonder why attorneys don't get involved in that coordination that Fred was getting involved in. And he had a lot of success, and that's going through the local governing, pretty much a jury, Kirk. The local legislative body gets the vote saying your federal policy isn't consistent with what we need here locally because it's upsetting the social and economical environment. And I really think this applies to COVID and also red flag laws, additionally to that. So I'm looking forward into trying somebody, local legislative bodies that have a pair that want to stand up. What it is that you follow the money trail after they pass these trillions of bailouts, and everybody's taking the money and trying to sell out your rights that are for sale. I mean, these people need fired and, at minimal, and probably should go to jail.
Right. The thing is this isn't supposed to be, let's make a deal. This is either prove your shit or get off the pot. And that's what I'm doing now is I'm forcing the showdown. You're going to have to prove it. Plain and simple. All of it.
I think
everything you're acting under, everything you got in this paperwork, I want you to prove it.
Shouldn't the qualifications to be for a legislature that you need to at least know about 10 of the amendments, to the Constitution? Do you think that would be a good start?
Here's the thing. I know Idaho might be special, but this is published by our Secretary of the State. Okay? We got the state constitution, federal constitution, and the Declaration of Independence. All right. You have to at least know this to work in government. If you don't know the basics, the laws of creation, the law being laid down, declare, right? We're declaring the law. of the nation called America here. If you don't know these three documents, fundamentally and principally, you shouldn't be in government at all. Because you're supposed to be bound by it.
So what difference if you're a Democrat, Republican, or independent? It doesn't matter what you have after your name, who your party affiliation is. You all have the same oath.
Can you show me those parties in here?
I know, right?
I haven't been able. I've read through this thing a few times over the years.
Well, that's how they get.
I haven't
their
found parties in there at all.
That's the lobbyist. It's funny. These solicitors are kind of like the lobbyists in Washington, D.C. These scumbags, they find themselves on like 5 or 6 different township boards. And so they're getting 6 paychecks. And then they're advising the elected officials to go against that document you were just holding up. I mean, and you know what? It's not gonna say them. Well, I listened to my solicitor. Well, nobody twisted your arm to swear that oath. Sorry. No one, when you cash that paycheck, nobody twisted your arm to go down and deposit that.
That's right. No, Mark, I'll have to disagree there. Chris Ann Hall says that they teach constitutional law. No, they do not teach constitutional law. They teach case law, and I got that right straight out of a bar member's mouth. Okay. They didn't teach him the law in law school. They teach him exactly what Tony was just talking about. Case law. Fred Kelly Grant trying to sit there and tell Tony, oh, you got to do case law, case law, case law. Now here's what Chris Ann Hall has said. I've been to one of her seminars. Actually, I've been to a few of them.
She was speaking last year at We the People.
I know. I spoke right after her last year.
I know. I don't think she liked what you were sharing, Kirk. Even
probably not. I exposed the bar as the fraud that it is last year. Again.
What don't you understand about the word constitutional attorney as an oxymoron? How can you use those 2 words in one sentence?
Right. But what she has said is that crap.
I love Chris Ann, but go ahead.
Oh, I love her too. Constitutional law. No. What she has talked about case law stuff is yeah, that's the law of the case. Because remember, when we read things backwards, forwards and back, 2 plus 2 equals 4, 4 minus 2 equals 2. That's how checks and balances here. So case law is the law of the case, and it's a contract. I don't know how many people don't know this, but when you do a case, this is all contract law. That's why you have to do your paperwork. If you don't do your paperwork, you lose by default. Just like in the game of tennis. You don't hit the ball back, that's a point by default. You lose. So a lazy man loses, a maxim of law. So like she said, yeah, it's the law of the case and only applies to the parties to the case. Are you a party to that contract? Are you a party to that case? Then it doesn't apply to you. That's exactly what she said. This was, I don't know, about 3 years ago, when she was out here at Meridian. Doesn't apply. So
yeah, I really like when she starts sharing on religious liberty. I really that's my favorite subject of hers.
Yeah. The thing is case law, and in our form of government, I can't find this in here, but maybe somebody else can, that the judicial branch does not have the authority to make law. And in fact, none of the branches of government have the authority to make law except for through a convention. Would be an Article 5 convention. And then it has to be submitted to vote to the people. So fundamentally and principally, we know for a fact that the judicial branch does not have the authority to make law. So why are we arguing case law? Oh, well, because that's the common law. Okay, well, the 7th Amendment says suits at common law. So it would be suits at stare decisis, suits at case law, exceeding the value of $20. The right to a trial by jury shall be preserved. And no fact tried by a jury shall be heard in any court of the United States. Whoops. In any court of the United States, except for pursuant to the rules of the common law. That means there's supposed to be common law courts that are not courts of the United States. And if you've got an appealable issue from the common law court, then it can go into a court of the United States, but it still has to be heard pursuant to the rules of the common law.
Well, they call it in Pennsylvania, their lower court is the Court of Common Pleas.
Yeah.
And then they have the next level up is the Commonwealth Court of Pennsylvania. Pretty interesting. Yeah, I've never seen a court the way they operate here in Pennsylvania. I thought California was pretty crazy. You get way more due process in California than you do in Pennsylvania. It's absolutely insane over here.
Well, it's because they're a commonwealth and they're still stuck on the English way, which is courts of chancery, and they're actually claiming it's under the equity, when equity is supposed to be about land and equitable interest. They fundamentally altered what equity means equality. Yes and no, but not in the sense that your bar code is twisting it. It's an equitable interest in the land, because it says suits in law and equity. That's in equity, equitable interest. And then later down, that's Article 3, Section 2, by the way. And then it talks about land as it's laying out subject matter jurisdiction in Article 3, Section 2. So that equitable interest is in the land. These courts of chancery that they're claiming are equitables are supposed to be the probate courts, where you would do land disputes, right? So, what Chris and I come up with and had taught before is they're using the scale of equity instead of the scale of justice. And we've tried to teach people how to hook yourself onto that scale of equity and turn it back into the scale of justice, and get that scale of equity out of there, because it doesn't belong there. So.
Yeah, the prosecutor's office has no interest. That they have no interest in justice. It's their idea of success is a conviction rate. I mean, it's disgusting. The old saying is that that these prosecutors can get a grand jury to indict a ham sandwich. I mean, they had eight Brady violations at the Bundy trials. 8 different times.
Yep.
And that guy just gets demoted. Unbelievable.
Yeah.
So you were going to send someone to jail for 100 years because you hid evidence. That sounds to me like a crime.
Yeah, that sounds like a public offense to me.
But don't they get absolute immunity, Kirk? I think you got to qualify for that, like you qualify for a job or a loan or whatever.
I don't know. You would think, right?
Yeah. Qualifications.
Yeah, in order to receive the emoluments of the office, you probably need to pass this test, right?
Might as well throw in it. Oh, the other thing is what's interesting are these people filling out these religious. So Penn State University, guess who they're getting to enforce these COVID restrictions is through oh man, I can't think of it. But anyways, people were putting their religious exemptions in, and then they're following up, questioning them. No, it's the affirmative action. The affirmative action officer is the one that's going around denying everybody for their exemptions. And they're, you know what I mean? And they're different, classes. I mean, where's the affirmative action when they put that little extra freeway road? If you're driving in California, if you pay a little bit extra money, you could go in the certain lane that is privileged for those who want to pay extra money. Think we
Right.
need to have some affirmative action on that. Um, yeah, it was interesting how Jesse Jackson and Al Sharpton would go to these companies, and what it is if they didn't have so many people of color in their leadership situation, is they would pretty much blackmail them, saying, you know what, we're going to be affirmative action, and basically you're gonna you're gonna end up spending several $1 million in litigation. So we're just gonna give you like a week to hire about 6 more people in leadership. And so yeah, it's crazy of how everything's being twisted anymore. It's just it's outrageous. To me, that sounds like bribery and extortion. But anyways,
Right.
but so Penn State University, I think we got about like 30 people that are ready to file separate lawsuits in groups of 5. So they're going to have like six they've gotten probably at least 30 lawful notification letters from the people attending my classes. So here in Pennsylvania, so they are probably hating me. And they're not responding. They're tacitly agreeing to prejudicing a certain class of people.
Well, well, again, kind of like something that we were talking about here earlier is the fundamental principles here. We're all created free and equal. That's some two basic fundamental principles that is at the root of all law, right? Do not cause injury, loss, or harm to the people. That's just that. It's the law of nations, law of nature. Fundamentally and principally, we're all supposed to be free and equal, which means that no man would have any authority over another man. You can't dictate to another man. Period. That's using force and threats of violence. If you don't, that violates some basic fundamental principles of law, God's law. That's self-evident law that the Declaration of Independence talks about. Let these truths be submitted to a candid world. This stuff is supposed to be self-evident. That all men are created equal. Oh, well, that's just men. That's right, because the other one is, whoa, man.
Yeah, it's interesting. When you watch the Braveheart, the Braveheart movie, when that one king, whatever his name was, he kind of made a deal with all the nobles. You know what I mean? We're going to piece you. We'll just give you a cut of the pie just to go along with what we're doing. I mean, that's what's kind of going on with these solicitors and these school boards taking all this money.
Yeah, it's all about money. Well, I wouldn't say it's all. There's some people in there that are legitimately evil.
Yeah, that's true.
Right? I mean, those are the kinds of people that they have to have in there to begin with. Money is pretty much irrelevant to some of them.
No, yeah, it's control. They're
some of
control
them
freaks.
get off on being, power hungry and
yeah, there's a lot of information that you could look up and find out your local school district on how much money they actually did receive. And that's something that I do in the lawful notification letters, is pretty much make the claim that you did receive funding, this school, to enforce these unlawful COVID restrictions. And what's interesting about the fraud is after the CDC comes out and admit their fraud that 94% was not really actual cause of death, they kept on perpetrating the fraud after they were called on the carpet. So how could it be a state of emergency if 94% was illegitimate? But they kept on, you know what I mean? They're executing their plan. New World Order.
yeah.
You'll own nothing and you'll like it.
Yeah, the old geese of give us your land and give us your gold and we'll take care of you. I don't think it's going to work this time.
No.
I mean, they've done it over and over again throughout history. And for the most part, the people fell for it. But in today's day and age, where we have the technological advancements, where we can communicate in an instant, even 20 years ago, we couldn't do this, right?
Yep, that's why the Bundy standoff in Nevada was successful. The feds backed the, I wouldn't even call them the feds, the mercenaries, the people impersonating federal agents backed off, got in their SUVs, and they tucked tail and left.
Well, that's because the sheriff stood up.
Well, the sheriff did stand up. Yeah, that did help.
So I have to applaud that man. I mean, that's some big cojones. Of course, look at all the people he had behind him. And that's what it's going to take, right? Is the people got behind the sheriff and said, look, sheriff, come do your job. Tell these people to get the heck out of here. And I mean, I remember I was all over this when this was all going down. And well, actually, I was not over on the 2016 stuff or 14, the Pahrump, Nevada. I came in later in 2016 with the Hammond stuff over there.
Well, it unfolded real time through YouTube Live, and to the people who were watching it, they were watching it unfold real time. You know, that was pretty crazy.
Yeah. So no, that was 2014, 15, 16, 16, 14 in Pahrump, Nevada. Anyways, I remember listening to some stuff there, and they played some audio recordings of the sheriff and the phone calls between the sheriff and dispatch and the sheriff and others. And the sheriff had basically said, look, you guys need to pack up and get out of there.
Oh, yeah.
Those people are going to come get their cows, and you're going to be gone when they come to get them. All right, you know. And then it was, oh, hey, sheriff, they're still there. What? I told them people to be gone. But he also wanted the people to wait, right? Well, as soon as the sheriff said, yeah, I'm telling them to leave, that's all they heard. And they're like, well, let's go. And
well, did you see them? They kind of marched backwards when it did happen, though.
Yeah. When the sheriff showed up the second time and was like, all right, guys, you guys pack up, get in your rigs, and get out of here right now, like I told you to before.
Well,
but we're FBI and we're BLM, and I don't care who you are. I'm the sheriff, and I'm the highest lawman in the county here. You're on my land, and you're in my jurisdiction. I told you to get out of here and pack up. And they're all backing up with the guns all drawn, and it's like, yeah, you guys were the aggressors. Oh, what about that kill list you guys had? Oh, yeah. Would that be that denial of exculpatory evidence? One of the things that they were trying to deny. The big part was the laptop.
Yeah,
that was the ultimate one that finally, the straw that broke the camel's back was the laptop.
Yeah, and it helped happen the whistleblower, that Wooten.
Well, and then the laptop comes up missing. When it come trying to do the third trial, now all of a sudden the laptop comes up missing.
These guys are criminals.
Right out of evidence. Where's the chain of custody on that? Somebody ought to be in trouble. Tampering with evidence.
So, yeah, people need to write these lawful notification letters. Can I share a victory with you? You know about it, but maybe your audience doesn't.
Yeah.
You know, it's ridiculous. We got 3 C's in life. We have covenants, contracts, and consensual encounters, and stuff that we consent to. And it's ridiculous because when this individual, I'm not going to use his name or how I'm related to him, but when he was denied, he went to purchase a gun. He was denied, and then they sent him a letter saying that he was denied. And so we decided. I got one of my one-page wonders here that had a good thing, good testimony. But they're using the Pennsylvania State Police to create this list of who can bear arms and not. Remember, guidance are not supposed to use mandatory language such as shall, because shall means what it is, or shall not. And the right to bear arms shall not be infringed. And when you pay your debt to society, it's over. You don't get put on a list. You paid the bill. You went and did the time for the crime or whatever his little infraction was, which was 30 years ago. So we put attention, Lieutenant, to this female officer, Pennsylvania State Police Department headquarters, Harrisburg, Pennsylvania. This is a lawful notification letter that you're corresponding with one of the people of Pennsylvania. See attached affidavit of status. So we put the affidavit of status attached to this one-page letter. On August 10th, 2020, I received your signed letter stating that you have infringed upon my secured and guaranteed right, specifically the Second Amendment of the United States, and further violating 42 USC section 1983. You have also violated your sworn and subscribed oath of office, which is felony perjury of your oath, because you falsely believe that codes stated in your letter supersede clearly established law, specifically the Second Amendment. I will be giving you an opportunity to reverse your decision. Further, a nonviolent controlled case over 3 decades ago does not qualify me from my secured and guaranteed rights. Please respond to the following. Number one, you have taken a signed oath and swore to uphold it to the United States Constitution and the Constitution of the state of Pennsylvania. Is this correct? Yes or no? You denied me my right to purchase a gun in Pennsylvania. Is this correct? Yes or no? Yeah. You wrote and signed an enclosed letter on August 4th, 2020. Is this correct? Yes or no? I will be monitoring and maintaining a record of your response or lack thereof. I will require you to respond within 14 days or your silence is tacit agreement. Respectfully submitted, yours truly. And so she said it took her 3 weeks, but she sent another letter, which is a one-page letter, basically saying, show this letter to the people and give them this code. We gave you a case number. When they type in that code, your restrictions will be lifted. No lawyers, no $5,000 retainer to try to get your what belongs to you to begin with. So people need to take your class and learning on how to write these lawful notification letters, bro.
Yeah.
And if it's criminal, they'll be more lengthy than these civil ones. That's for sure.
Yeah. Yeah. It's, again, back to the first fundamental principles, first step of due process of law is notice and opportunity. So what does that mean? It's a lawful notification letter. You're putting them on notice. And, in the way I word mine is that I say that they're making errors, right? Thinking errors. To err is human. It's given. But after notice, it's no longer an error.
It's called deliberate indifference.
Right? You're either of sound mind, possessing logic and reason, and what is it? Let's see. Your sound mind, possessing logic and reason, shall come to a reasonable conclusion based in reality, or you're insane. So either you're of sound mind or you're insane. And in our settled civilized society, we shun the insane. And if you're claiming that you're in some sort of public servant receiving taxpayer dollars and you're insane, you're incompetent. Vote of no confidence here. You're out. We can't have the insane be in the position of an emolument here.
Well, these most have vacated their seats of authority where the inherent power resides. It is within you, but you must open up your mouth. You must notify these people and give them fair notice that they are going to be fired.
Huh. Yeah. Plain and simple. Speak the law. Become the law sayer. Oh, wait, no, that has to do with the bar. No, that's the problem. We've all been dumbed down to believe that only these members of the bar that went to law school are the only ones that can know anything about the law. When we have two maxims of law here. One, ignorance of the law is no excuse. Number two, to know a thing and to be bound to know it are regarded in law's equivalent. And then, of course, the Declaration of Independence. These truths are to be self-evident. Oh my gosh. If it's supposed to be self-evident, that's that common sense law. Oh man. Yeah, we're already supposed to know the law, folks. There's no special law school you're supposed to go to learn this stuff. This is supposed to be common sense.
Yeah, you might want to start by reading the Bible.
That is a great place to start.
I mean, the
Lots
Ten
of maxims of laws from the Bible.
The Ten Commandments are very easily understood, you know?
Thou shalt not commit murder. Thou shalt not steal. Thou shalt not bear false witness.
Yeah, and people say
that's pretty straightforward.
You know, it's funny that people say that that bearing false witness is lying. No, bearing false witness is getting up in a legal or lawful proceeding and giving misappropriation of facts and bearing falsely of what you witnessed. So it's a little bit more weightier than a lie because you're doing it under oath. You're being a witness. And you know, I love kind of what Christ said. He said, woe to you, you lawyers. If I guess it would be probably translated to attorneys in our day, says you take away the key of knowledge. Not only do you not enter into justice, but you stand at the door and stop others from entering in. And the reason how they take away the key of knowledge is they're convoluting, like what you and Chris always says. They just use a bunch of word salad, and you know, and if we start losing our lawful or our legal arguments, then we'll just change the definition of the word. Did you hear how the CDC came out and changed the definition of vaccination? How can they possibly think they could do that? It's just.
Well, that's the thing is, what is it? I don't care what word you use. It's a bunch of shit in a freaking vial and you're putting it into a body. Now, what's the ingredients?
Yeah, that's a good question.
Full disclosure here.
Yeah, they haven't produced
these
the ingredients yet.
Doctors are supposed to have their Hippocratic oath, right?
Yeah, it's becoming
all the medical field. They're all supposed to have this Hippocratic oath to do no harm. Well, wait a minute. That's a fundamental principle. The main fundamental principle is to do no harm. So your Hippocratic oath just falls in line with God's law. And the first fundamental principle of God's law is to do no harm. How are they in good conscience? How are they not violating God's law? How are they not violating their Hippocratic oath? They know what's in it. They have to know, right? Ignorance of the law or ignorance of the shit made up that you got there in your hand that you're jabbing into people's bodies. Where's the full disclosure? Where's genocide. The choice?
Yep. Domestic terrorism to coerce and intimidate a civilian population. Domestic terrorism. It's absolutely insane.
Yeah.
I'm even impressed how far they've taken this fraud, and probably because not enough people were standing up. I mean, once you know the law, it's almost like an obligation to stand up, I think, you know.
But we're already all supposed to know this. Again, this stuff's supposed to be common sense. I mean, do people have to hit their thumbs with a hammer to know that it's going to frickin' hurt? I mean, at this point, I'm willing to start helping people smash their frickin' thumbs with a hammer just so they know that it hurts. Come on, people, let's wake up.
Yeah, I talked to some
I
lady
mean,
in the
seriously.
checkout line. She flat out told me, I'm afraid to step up because I don't want to be targeted. Well, I says, well, then I guess we're just going to lose our country if everybody's afraid to step up. I mean, because I think you always win when you stand up. I don't care if
Bingo.
if you get the desired result. You know, to stay silent is to agree. You know.
Yeah. Well, silence is acquiescence, and the lazy man loses. So the thing is what I heard there is I don't actually know how to defend myself. So I'm too scared to do anything because I don't know how to defend myself. And that's the problem. People don't know what to do because
Yeah.
they haven't read it. They don't know
Yeah.
the
Well,
limitations of government and don't know how to point to this and go, no, this says this, and you're bound by this, and you can't violate this fundamentally and principally. And anything that comes in conflict with this is void for any effect. But if you don't read that, you don't know jack shit about nothing about government, about what our nation is founded on. You don't know what our fundamental principles of law are. This is basic common sense stuff right here, folks. You got to know this to make any kind of a lawful argument. Not legal, lawful. Because even contracts, which are legal instruments, have to be lawfully obtained.
if you get hired at McDonald's, don't you have to read the employee handbook? You know, I talked to a Pennsylvania state legislature and asked him if he had read Mason's manual, and he said he didn't.
Right.
So this guy told me that all his Republican leadership told him to stand down against the COVID. He went and told that to our group of people that I was co-speaking at an event. And this guy, after telling everybody that, votes to extend the emergency till March after saying that himself to his constituents.
Wow.
It's just unbelievable. Unbelievable. That's pretty much willingly and knowingly. You know, you disagreed with it, but you voted for it anyways.
I know. I know. There's no moral fortitude left.
So his answer to people was stop complying, that was probably the only wisest thing that came out of his mouth. But and the other thing is people want to sue when they are consenting. If your kid goes in wearing a mask and consenting, and he has not been violated because he consented. You can't claim rape if you said yes and you agreed and you went along with it. So people, if you want a cause of action, you have to get violated. You don't consent.
Yeah.
You know, they're putting these kids in the library or in separate rooms by themselves. So they're not, you know, applying the law equally across the board to two different people with different beliefs. With all that extra money that they're getting, hundreds of thousands of dollars, they should have two classrooms if you're going to do equal consideration under the law, you know, full faith and credit straight across the board. Well, the people who don't want to wear masks, they get to have their classroom, and then the mask holes get to have their classroom. And so there's plenty of money to go around. You know, they took the money, and so I don't know how they're going to get around that argument, because I haven't seen that one adjudicated yet here in Pennsylvania.
I mean, that's kind of what's going on, though, isn't it? People are just
Yeah, they're
complying.
not. They're. It's even though it's below the
And
line, it's blatant 14th Amendment, blatantly. And you know,
well,
they're held to the standard. The codes and everything below the line is for them anyways. So that's their standard. That's their what they signed up for.
Yeah. And it can't have the force and effect of law on the people.
Even in the guidance document, it said that if you're a
Yeah.
non-government employee, it has no full force at all.
Right.
And even though you're an employee of the government, you still have religious values and you still have a conscience. I'm not going to play Russian roulette with my health.
See, this is the thing. I know this might even come to a surprise to you, but when we're talking about the constitutions, that institutes government, and the individual who takes that position, this is the stuff that they're all supposed to be bound by. They're already those amendments in the Bill of Rights, that's already the common law, but that's enumerated for government to ensure that government doesn't treat the public servants and deny those rights, which is why Hale versus Hinkle says what it says, that the individual may carry on his private business how he sees fit, because he owes no duty to the state. Oh, right.
Are you going to hit Hale v. Hinkle at the conference?
Well, I know you are, right?
Well, I'm going to share. I'm not in detail as you are. You know it better than I do, but I'm just trying to enlighten the people just through the main opinion of the case, is that there's two different classes that you could be in. You could be a natural person or an artificial person. And if you want to contract, you're welcome to do that. And if you're going to be one of the people, you should exercise your civic duty. Stop vacating your seat of authority, and we're losing our republic because of it. And so knowledge is power. You come to these seminars to get empowered. I mean, the first time I heard below the line, above the line, below the line, Kirk, I stood up on the inside, and I don't think I've ever sat down again. I'm like, what am I doing consenting to this stuff? This is ridiculous.
Right.
Why would we hide? Why would we think that, oh, wow, I'm afraid of the Internal Revenue Corporation, It's just nonsense. Every lawful notification letter that we've sent to the IRS asking them, it's a conditional offer letter. I'll be happy to cooperate with this investigation. Just send me a certified copy of your sworn and subscribed oath of office, and we'll get right on it. Not one. I've never seen one oath of office to an IR agent, which pretty much to me is telling me that they're not a government agency at all.
Well, they're not. Even the whole IRS code is not law. Right?
But they have instilled fear because of ignorance.
Right. Because of ignorance.
I don't even think their courts are real courts. They're just administrative little sessions, as far as I know.
That they're not government.
Yeah.
So what the hell are they?
Well, every year around March and April, you have all those commercials on TV and on the radio. Oh, we'll negotiate your IRS debt that you owe. And
where's the full disclosure? How about the ingredients of the IRS? That's that. What was that? That's the internal rectum service, isn't it? When you call them, they're asking you to push the pound key if you feel your rectum is in need of service. No.
Well, I mean, the only way to really, I think, if they're dragging you into litigation and into forensic audit, I think that's when you have to stand up. You don't have a choice anymore. I was pretty much backed into a corner. And it's funny how, Kirk, seriously, I hate to admit this, but years ago, I was afraid to go to the mailbox because of the continual letters that would say, we're taking your cars, we're taking your house, we're taking this, we're taking that. I'm like, oh no, Kirk, this letter they sent the last time has a red line on it. Oh no.
Right?
Yeah, the final notice,
I
to
was
put a
just gonna
little
say
orange
final
stripe or
warning,
something. Yeah.
final
And then you
warning,
open it
final
up.
notice.
It's funny when you open it up, it goes, "This is not a bill."
Who's Bill?
Exactly. I hate that guy. Yeah, that's another
Uh,
one page. That's another one page wonder right there. Because I think effective fair notices and send courtesy and follow up notices to these people. Like, oh, by the way, hasn't your mom taught you manners? When somebody writes you a letter, public servant, you're supposed to write them back. You didn't send that. So I'm enclosing a copy of my first lawful notification letter to you to try to just give you a little bit extra time to answer this one. So I'll be waiting.
yeah. Yeah. We need to come together, and the people need to come together in unity, one nation under God, indivisible, with liberty and justice for all. And if we can't come together under this, we're screwed. Which means you're going to have to read this, comprehend it, and understand it.
So it's interesting how even these Liberty Caucus legislators go in to try to visit with the January 6th alleged insurrectionists who had no weapons on them, by the way. How interesting. And these guys are being held without right to a speedy trial, similar to the Bundys and Eric Parker and Scott Drexler and the rest of them guys that were held for a year and a half before it even went to trial. Um, I wonder, did you see the press conference? They tried going in and they were blocked.
I was broadcasting live that whole event all day.
Oh, okay. I didn't see it. So
And when there was this alleged, break-in stuff started happening, and oh my gosh, we all got to go into hiding, and they stopped the video footage, right? So we scurried around, and we, with the little team behind the scenes, which is here right now. Here, check this out and check this out. They were hitting me with giving me links to videos, live videos of people out on the streets. And I showed that stuff, what was actually going on. I showed the part where there looked like police officers dressed in kind of black suits, and they're pulling the fencing back. Come on in, waving them on the backside. Come on in, come on.
so
And then the
can't the
video footage that surfaced later of going into the Capitol, and the two officers are like, "Yeah, come on, come on, come on."
so that
It was a setup.
the 9/11 commission withheld exculpatory evidence that we've all seen. So I think we need to sue the 9/11 commission for insurrection. They're trying to subvert the rule of law by
Yeah.
by you know
That's domestic violence. That's internal insurrection.
so this whole 9/11 commission, what type of action you think would, if you were to endeavor in doing this? I know you're a little too busy doing a bunch of other stuff, but to file a grievance and claim against the 9/11 commission, because it was a political stunt, but they spent millions of dollars doing it, and then they ignored all the exculpatory evidence. And as a prosecutor, you cannot do that. So I guess that was Pelosi's abortion, or what? That Didn't she put that thing together?
The 9/11?
No, not the 9/11 commission. I'm sorry, the January 6th commission. My bad.
Oh, I think I
Two,
just got confused. I was
I
still
might have
I was
said
reading some
9/11.
comments over here.
I meant January 6th commission.
Yeah, I'm not sure who was behind it. I have,
Well, they had a bunch of hearings. They held hearings and withheld exculpatory evidence and had all those people go up and cry in front of the camera how that they were emotionally abused by the protesters.
Basically since that day, I've pretty much turned off anything to do with the Biden administration. I've unsubscribed from YouTube channels and all that stuff that puts anything out like that crap. I've been focusing on the law stuff and doing what I need to do. I know this is all fraud. I know that it's unconstitutional, it's unlawful. Um, and like Trump said at the inauguration speech, plain and simple, I'm putting the power back into the people's hands. And how many times has he said out there, oh, somebody ought to sue these people? I don't know, I'm most definitely having the feeling that Trump's not coming to save us, folks.
Nope.
Come on, it's up to us to do this. So,
Liberty begins with you.
that's right. If I mean if all political power is inherent in the people, it doesn't say all political powers inherent in Trump. It's up to us. We got to be able to effectively claim and exercise and defend these rights. Period. That's what this whole republic was built on. The militia being necessary for security of a free state, the right of the people to keep and bear arms shall not be infringed, because the militia is every able-bodied male between the age of 18 and 64. That's the unorganized by government militia. A militia being necessary for the security of a free state, a state of being free and equal. The people have the right to keep and bear arms, which shall not be infringed by government. That's our republic, if we can keep it. So, that's the duty.
Can I read another shit sandwich?
Yeah, you bet.
Okay, this one guy,
I'm actually going to take a
he put his school district on notice. And so I'm not reading their letter, but they're like saying that we'd like to remind you of the health order. Okay. And so they're reminding him of the code. And so we sat down, and his rebuttal to them was, this is a notification of violation to school. Okay. I have received your letter dated certain date that you claim as a reminder of the mask order. They're reminding. So his reply was, I would like to send you a reminder that as an educator and public servant, that the Declaration of Independence, the U.S. Constitution, and the amended Bill of Rights are the supreme law of the land. This letter is also lawful notification that you and other actors working in concert together that have infringed upon guaranteed and protected rights under the constitutions, both of them, federal and state. Hey, calling it federal, but anyways.
Right.
Your retaliatory animus against my family has been noted, and I will be monitoring and maintaining a record of these said infringements. It has also been noted that you sent my son home without even being sick, nor did you consider checking him for any illness prior to physically escorting him from the property. As a result of your actions, I will be proceeding pursuant to 42-1983. Basically, you've just become primary defendants in a federal lawsuit. I'm paraphrasing. Any further actions against my child will be considered retaliatory animus against his constitutionally protected conduct. When your child goes into school without a mask, that is constitutionally protected conduct. Please respond to the following. And these are you don't want to ask questions a lot of times in your lawful notification letters. Well, you can ask questions, but if you make statements,
Yes.
then they're acquiescent to the statement. If they don't answer the question because they're not in the presence of an attorney and they want to claim ignorance, well, I can't answer these questions unless they're written in interrogatory form or admissions. So when you make the statement, you bring like Kirk always says, bring the cause of action. And one of some of the statements we're making in this letter is such and such school is receiving financial incentives for enforcing health department regulations. And then you can ask a question after that. You've made the statement. Is this correct? Yes or no? Such and such school is receiving federal funds with the obligations to enforce health department guidelines. Statement. then question, is this correct? Yes or no. School board members and other officials and leadership in this district swear and sign a oath of office to support the constitutions, meaning, the United States and the Pennsylvania. And getting back to when people say, well, there's another constitution, that's to the Vatican. Well, you know what? Even if that's true, they still swear into the state constitution, so they can't get out of that. Actors from such and such school sent my child home over guidance orders. Just admit it, right? Okay, and so you give them 14 days, you close it up, in your conclusion, you give you 14 days to respond. Also be advised that other vicarious liable individuals in your school district have violated my son's first, fourth, fifth, ninth protected rights under the Constitution. To avoid litigation and adjudication, I will be willing to meet and confer. And this is what the federal courts like to do, is they want you to meet and confer before you start bringing stuff before a judge. And so when you use that type of language like fair notice and meet and confer, when the bad actors, you send your nulliful notification letters, their bar members are going to know exactly what you're talking to. And that's why it's good to use specific language like that. In conclusion, I will be willing to meet and confer for a narrow window of time and opportunity. Please be aware that you are receiving a registered certified mail that will follow up this email. So you're always creating evidence, creative public record, CC everybody.
I do notice to agent is notice to principal. Notice to principal is notice to agent. So
they are obligated. Yeah, I like that. That is, I think that is proper. But what you just said.
Right. I pretty much start my lawful notification letters with that. Right above that, it's to know a thing and to be bound to know it are regarded in law as equivalent. It's a maxim of law. So
we wonder why these judges look at case law on a higher plane than maxims. It's ridiculous.
This is what we have to get back to: maxims of law, because that's the rule of law, like a rule of procedure. The rule doesn't stand alone. It's a rules of something. I had this argument with some people down there at the Capitol on August 25th when we were down there. Now I'm not going to mention their name here, but the fact is, oh, well, they have the power to make rules of procedure. No, just rules. No. You're not saying the whole phrase. It's rules of procedure. Right here in the Constitution, it says that they have the power to make the rules for their proceedings. And then I found it in the Idaho Code. It specifically says that they have the power to make rules of procedure. Whoops. Because it's the Mason's Manual of Legislative Procedure. It's the rules of procedure. So when we say rule of law, it's the rule regarding of law. So to know a thing and to be bound to know it are regarded in law as equivalent is a rule of law. It rules over the law. Now, I actually got some little tip from a Jesuit, no less, who was exposing the whole thing going clear back to 400 BC. This man's a Jesuit. He admits that, look, I'm a Jesuit and I'm telling you the truth here, that this is what they've been organizing and doing since 400 BC. And he's laying down names and dates and, all this stuff. And in the end, it was like an hour and 43-minute video. He says, if you want to be effective, grab your Bible, read it, and start using maxims of law. I'm like, ding, 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 winner, chicken dinner, because that's what it is. It's the rule of law. What I cannot do in my person, I cannot do through the agency of another. Let's break that down into common sense here. If I can't do it, I can't task somebody else to do it. For example, can I commit murder? Not lawfully, right? Thou shalt not commit murder.
Yeah.
So can I task an agent of the government to commit murder? I mean, this is what we're talking about. The rule of law is being common sense here. If I can't do it, they can't do it. And remember, they're all agents. Agents have to have a principle to act on behalf of. But this is what they're doing. They're prosecuting by information, these writs of assistance. Here in Idaho, well, pretty much everywhere. They've tied this all in under the uniform traffic citation, which is why they want us to have a driver's license, because that's the contract that would bind you to all this crap, which is all fraud to begin with.
That guy could
uniform traffic citations for misdemeanors and felonies, and it's like, no. Where's the principle you're acting on behalf of? Well, you didn't use your turn signal, and then we found some drugs in your car, and well, I think I have the right to be secure. My purses, papers, houses, and effects. This would be my effects. Where's your warrant describing the person, place, or thing to be searched and seized? Oh, you don't have that?
You
well, that wouldn't be lawful for an agent to do. What's the name of the principle you're acting on behalf of? Well, the state of Idaho. Well, the state of Idaho is a fiction body politic. Remember, we went through this in your case in the motion in limine.
Yeah.
Mr. Gay Zimmerman.
Yeah, that what a piece of work.
I've showed that on the show a couple different times.
That was funny when we did that Facebook Live. It magically disappeared of what you're actually and what is it you're actually auditing? He turned as white as a ghost.
Yeah, we're conducting an audit on the case, and to see, we're looking for emoluments violations, and to break it down into layman's terms, essentially we go after bad actors in government who trespass the law for emoluments violations.
I went into that administrative office at the Twin Falls courthouse there, and I talked to the lead administrator. I'm like, I'm here to let you know that everybody that works in concert or directly violates my rights, I'm suing everybody in here. And it was funny, every time I would go into, for some reason, to that administrative office, because I would walk around and make myself comfortable in the people's building. The emolument was paid by the people. And that lady would always like, Mr. Pellegrino, do you have everything you need? And you actually know that I'm giving you everything you need. Like, she's like, don't add me onto the lawsuit.
Right. Speaking of that particular case down there in Twin Falls, for the viewers and the trolls out there, remember what happened there? Remember when the first time I went down there and you asked the judge if you could have your assistance of counsel up there? And then we filed you filed the practitioner's judicial report.
Yep.
And then we came back down for trial, and you asked again if you could have your assistance of counsel up there. And what happened?
Oh, they says, come on up, Mr. Pendergrass. And then the judge refused to even talk to me and listen to me. He was looking at you the whole time.
He was kind of sweating bullets up there, and was outside having a cigarette, during the lunch break there. And he was coming back in. He's like, oh, hey, nice day out here,
I think he was on antidepressants, actually. If you're a state court judge, man, you got to try to numb the conscience down, because you're pretty much screwing everybody walking into that building. Pretty much so.
The judge was like, yeah, come on up, come right on up. Waving me on down. And I sat next to you for trial. Now, they tried to keep it so I couldn't talk to you, but I should have went ahead and just did it anyways and forced the showdown.
Well, he was showing you a heck of respect, the judge was.
Well, I was paying attention, hanging on every single word he was saying. And it's funny too, because he was going through stuff, and like when they were arguing about the witness thing, and well, da 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 da, and he articulated it and read from the law, and I'm like, well, yeah, he's got a point. All right. And the judge kept looking at me, like you were saying, he was looking at me pretty much the whole time. One thing that we didn't catch, when he started talking about jurisdiction, oh, well, we have jurisdiction under Article 3, Section 2, blah, 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 blah. Whoops, that should have been an immediate objection right there, because the prosecutor did not put that in writing. He did not prove jurisdiction in writing. So where is he finding these facts? Because he's supposed to do a finding of facts and conclusions of law. But see, the second he goes to Article 3, Section 2, that's Admiralty jurisdiction. You say, oh, we have jurisdiction on Article 3, Section 2. Well, the only jurisdiction that's enumerated in Article 3, Section 2 is Admiralty jurisdiction. And what? Suits in law, Admiralty jurisdiction, and equity involving land. How in the hell do they have jurisdiction over a man exercising his right of personal liberty? The right to the power of locomotion, choo-choo, vroom, vroom. The claim and exercise of a right cannot be converted into a crime. Miller versus U.S. You want some case law? There's some case law for you.
Well,
that should be common sense, right?
Yeah, it's 11:42 here. I gotta pack my suitcase and be ready to roll at like 6:30.
Yeah, you're coming here.
Yeah, my intern's been calling me because she's coming with me, so she's blowing up my phone like, we're leaving in the AM. Please call me back. So I'm doing laundry, and obviously my office is a mess. Look at this thing, man. I'm tearing it apart. Been busy.
Oh yeah, I know.
They say a sign of a clean desk is a sign of a sick mind.
Well, my desk at home and my desk at the office is cluttered. The desk at the office is literally books that are opened up to certain pages because I'm doing mass amount of research right now.
I know, my office is
there's books just all over my desk. I barely have enough room to freaking sit down and eat or do anything at my desk. It's just covered in books. And you know how big that desk is. Plus I got the side part. It's all covered in books. The stuff behind me full of books opened up on. I've been digging, dude. I've been finding all sorts of good stuff. Finding where they altered this and altered that.
Yeah, looking forward to seeing you, bro. I'm doing the deep
dive.
It'll be good hanging out with you.
That's going to be good to see you, brother.
All right. Well, thanks for having me on tonight, everyone. And come to the conference. Buck up and do it.
Get signed up for the pre-conference, the private law seminar with Tony Pellegrino and myself. We'll buy you lunch, catered lunch, for $100. You're going to get educated by Tony and myself, and a lunch.
Syllabus.
I got a syllabus. You're going to get some document templates and stuff, and we're going to get some down and dirty education real quick. I will actually. I'm working on setting up specific, breaking these down into individual classes, because an hour and a half is not enough to try and teach you everything I want to teach you. And what I am going to do is a brief overview of lawful notification letters, tort claims, and criminal complaints. But then I'm going to offer, this is part of what the team's been working on the backside of this, the other team, the school team, as we're trying to get a new website up, a PMA, the whole 9 yards, a whole like separate entity here. But what we're tentatively talking is 2 weeks from the seminar is to do an in-depth just on lawful notification letters on one class, and then a whole nother class on tort claims, and then a whole nother class on criminal complaints. So
It'll
yeah,
be good to have this foundational seminar.
yes, it
Definitely
will.
help. Well, thanks for having me, Kirk. Have a great night, everyone.
Thanks for coming on, brother. We'll see you in a couple days, right? See you probably
All right.
Thursday.
Yep. Much love, brother.
Much love, brother. Good night. Oh, folks, much love to my brother Tony. We've been hammering this stuff out for years together. It's been good working with him. I've seriously missed him, but he's been following God's lead for quite a few years, and was hanging out back down in California, and it just wasn't working for him there. And then family issues out in Pennsylvania, his dad. So he decided to go out there and spend some time with his folks before they pass away. And now it's coming to a point where he's wanting to come back to Idaho. So, all in God's timing here. He'll make it happen. But I think once he comes back here and sees what we've got going on at the office now, that again, this office is one that Tony and I started. 4 years ago? And then Tony left for California. We've expanded since then. We're technically speaking, we have 3 offices now. So he's going to get to see how much we've grown since he's left. And especially my law library. And thanks to Rob Logue, who happens to be on here right now, and Michael Klavinsky. Man, those books are so awesome. I've been digging through them like nobody's business, Michael. You have no idea. Seriously, that's some of the books that are laid open onto certain pages, just sitting there going, yep, here's constitutionality challenge to a statute. Oh, here's a writ of mandamus, a judicial mandate, a whole bunch of other stuff. I mean, there's just all sorts of stuff that I have open. But if it wasn't for you two and supplying those books, I mean, good books, some of the good ones. Plus, I've bought my own, right? I've got lots of other books that I've bought myself. Acquired a lot of law books over the last few years. Got to have it. Got to have this stuff to reference. So, hey, Miles, what's going on, brother? There's another one, part of their behind the scenes team, maintains the kirkslawcorner.com and being tasked with the new website. Gonna be some good stuff. Again, those folks there, Miles actually didn't go down there, but to California, but he did conference in. And we did have a couple different meetings there. So, but a lot of stuff happened this last Wednesday through Sunday with all of that, the school stuff, the PMA, the website, and the school that we've been working on putting together. And this is quite an undertaking. On top of everything else I have going on, which is part of the reason why I couldn't make it down there. And like what I've been recently saying is the fact that I've got so much on my plate, it's starting to fall off the sides of the plate. I just can't even get to everything I want to get to. But at this particular point, it's go time. We are actively engaged in the battle to take this crap down. So we will prevail, and the evidence and the truth is on our side, and it's just a matter of doing it properly, going through the stages, the steps, and filing the proper paperwork and proper challenges, and doing this correctly, following due process of law. I mean, this is how we're supposed to do this in a settled, civilized society. So this is where we're headed, and we're right in the middle of the thick of it. You know, this is it. It's starting to get to the point of, okay, let's start hammering this stuff out. I'm demanding your proof. And when you can't provide the evidence, well, then I have the right to abolish everything that you have been doing because you don't have any evidence to support your claims to the causes of actions that you have taken. All these members of the bar are out there, even the, the big wigs up there, all, spinning their wheels, trying to figure out what to do. It's like, how come you guys don't know? I didn't go to law school. Oh, yeah, that's right. Kirk didn't go to law school. He can't practice law. The hell I can't. This is my republic. All political power is inherent in the people. And if this is all supposed to be self-evident, and it's written right here, right? Well, all political power, right to petition the legislature for the redress of grievances. Yeah, there's some things that aren't in here. Mason's Manual Legislative Procedure is not in there. Parliamentary practice isn't in there. So yeah, there's a little extracurricular reading and research that has to be done. But once you get to a point where you know this, and anything that comes in conflict with this is void for any effect. I mean, Article 6, Clause 2, the judges in every state shall be bound thereby. Anything in the Constitution or laws of the state to the contrary are notwithstanding, which means it has no standing in law, which means it's void for any effect. That's what that means. Which is why Marbury versus Madison backs that up. Anything that comes in conflict with the supreme law of the land is void for any effect. Void ab initio. Void from its inception. I mean, how do we not know this? If you don't know this, how are you going to know what's fraudulent, what's void for any effect, if you don't know the fundamental principles first and what our form of government looks like and what the limitations of government are, including personal and subject matter jurisdiction. If you don't know that, you're not going to be able to know what's fraudulent. And again, constitutional provisions stand on a higher plane than statutes and are mandatory. Let me say that again. Mandatory. It's duh. It's that kind of common sense. This is like a duh. Yeah, duh. This stands on a higher plane than statutes. That should be common sense. Which came first, the chicken or the egg? Or which came first, the rooster or the egg? Oh, never mind. If a rooster lays an egg on the top of a roof, which side of the roof does it fall down on? Neither, because roosters don't lay eggs. So, I know it might be a trip for some people, but for my local peeps, out here in Nampa, the Civic Center, where we've been at for the last 4 years now, this is the 4th annual We the People Idaho 2021 event. Tony and I are hosting the private law seminar. Make sure you get registered there at acla@yahoo.com. That'll get you over there to Tony Pellegrino. He's got all set up to take the payments and all that stuff. So we're going to have that all set up. We're going to have the syllabus there for you. He's going to have his. I'm going to have mine. We're only going to get an hour and a half a piece. So, I mean, 2.5 hours right here, right now, right? 7:30. Oh, no, we didn't get started until almost 8. So, oh, no, I guess it's been. Where are we at? Oh, right at 2 hours right now. So, most of the time I do 2 hours. So imagine that. What I've tried to teach folks here in 2 hours. Now I've only got an hour and a half to try and teach you something in person. But like I said, we're setting that up to, right on, Michael. I knew you was coming. I look forward to it. Hopefully you'll have a little bit of time. We can maybe go out to dinner or something afterwards or something. I know last year you had to run, catch your plane right after the seminar. But yeah, look forward to what's coming here this Saturday, October 30th, 10 a.m. at the Nampa Civic Center. And the We the People event starts at 2. The private seminar starts at 10. And again, right on, you're going to stay overnight. Right on. Good. And we can hang out a little bit Saturday night. So, yeah, look forward to our 4th annual We the People event. And I hope we get the people to show up, because we need to start bringing unity. We need to start coming together, because if we don't come together, divided, we will fall. And there's no mistake in that. So unless we get on the same page and start understanding this and enforcing and supporting and upholding this, we're going to lose that. Yeah, I'm sorry. Reading the comments out here. So thank you all for tuning in tonight. I know it's been a while. We've been busy. I got banned on YouTube for talking about the election stuff, which is weird because the proof is out there. So I wish you could too make it, Scott. That'd be awesome. Be awesome for you to show up. But once we get things going and I start generating a little revenue and I have a little money to start traveling around and doing law seminars, make that happen. But as of right now, way too busy with everything we got going on, and no time to leave to go anywhere. But we will get there someday. Something that we had talked about, Chris and I had talked about, and was about getting a bus and traveling around and doing law seminars and coming seeing everybody. But unfortunately, Chris is not going to be able to physically be there, but he will be there in spirit. He's right here with us right now. I know he is. I know he's watching over me. I know he's going, come on, man, let's go. And I'm showing him, I'm doing it. Here it is. I'm doing it. I might be a little bit slow, but I realize I have to have a right up to a cause of action. And now that I have those causes of action, I have standing to claim those rights to a cause of action. And I'm going to do it. I'm going to give it my good faith effort. Take all the knowledge that I have and that I learned from Chris. I'm going to beat the crap out of him the best I can. So someday we'll have a bus and we'll travel around. But as it is right now, I'm in the trenches and we're at war. We're in a battle. We're in the battle for our freedom, our life, our liberty, and our pursuit of happiness is being stripped from us without just cause. So keep in mind, all political power is inherent in the people, not government. Trump isn't coming to save us. None of them are coming to save us. I hate to be the bearer of bad news, but I just don't see that happening. I don't see how it's even possible for one man or a couple of men or women to save us. It has to be us to save us. You know, it's like diving into the swimming pool and then screaming for help for somebody to save you. Why don't you learn how to swim? I mean, that's the key. You're going to have to learn how to swim here, folks, because we've all been shoved into the water, almost figuratively, literally, under Admiralty jurisdiction. And now it's so convoluted, it doesn't even resemble even Admiralty jurisdiction. This is all just a free-for-all. They're doing whatever the hell they want to do. And, well, catch me if you can. It's up to us to do something about it. When are we going to do something about it? And again, you can't even just depend on me. We need everybody doing this. We need everybody's coming together. We need everybody claiming their right to a cause of action, filing lawful notification letters, tort claims, and criminal complaints. We start doing that in droves, then we're going to start seeing liberty. Then we're going to start seeing the corruption being shut down because enough people come together and put them on notice and start getting them arrested. Because that's how it's supposed to be done. Lawfully, following due process of law. Now, paperwork. Okay? That's what we have to do. All right. Well, thank you all for being here tonight. And if you'd like to help support us over here, 6477 West Fairview Avenue, Suite C of Boise, Idaho. That's over there at the office for them postal money orders, regular money orders, cashier's checks, anything like that, gold, silver coinage. And thanks for the shirts. By the way, I've gotten like 3 different shirts now. Working on some digital stuff, getting something worked out on that, where I can actually take cards and donations and all that stuff through a legitimate, not through PayPal and all that crap. This is going to be legitimate for the business, credit card processing, all that good stuff. So that's coming. Should be here-ish by the end of the week. So, and I think I figured out, because of all this, I figured out what I did on Streamlabs is wrong. Why it's not working for the donations there is because I didn't put the correct routing number in. And now I'm having a heck of a time getting into it to where I can change it. I can't, I've tried. So I sent in a request for them to do something. We'll see how that goes. But otherwise, the only way to donate right now is through the office. And I want to thank those that have sent in donations over the time. And thank you very much. God bless. And we will see you. Patreons, of course, Patreon. You want to get on Patreon for our Wednesday night workshop, where obviously I'm doing more stuff there than I am here. And again, part of this is probably going to be going away because of how bad things are getting. We got to watch what we say on here or we get shut down. So Patreon is one of them, but the other thing is we're working on a brand new website for the school, and it'll be our own website. And yes, of course, make sure you hit the like, the follow, the share. both on Facebook and YouTube. Get that subscription going over here on YouTube for as long as it lasts. But patreon.com/Kirk's Law Corner. That's the Patreon channel. And quite a few of them on here. I also have the Patreon Telegram channel for tier 4 or tier 3 and tier 4 patrons. I'm recording the Wednesday night workshops now, and I'm putting them out there on Telegram. For those that can't make the Wednesday night workshop live, that's the remedy that I've come up with now, thanks to Telegram. So I didn't want to try and put them on YouTube because of certain issues with YouTube, and need to keep it private. So yeah, there it is right here. Fix it. Just put that up there. Let's see if oh, look what I just did. The heck did I do? Oh, I know what I did. Now there is the KLC Media Group News channel on Telegram as well, but there's a private Patreon one, just so everybody knows. Let me see if I can grab this. I'm trying. Keeps moving. So I can put this on Facebook. So here's the for those on Facebook, Patreon. There's the Patreon and the Telegram link for KLC Media Group. And then there's the Patreon if you want to get a subscription over there so you can get involved with Wednesday night workshop. All right. Much love, everybody, and have a wonderful night. God bless. And we will see you when we see you. All right. Hang in there. Oh, don't forget, We the People Idaho 2021. Much love.